I want in this session to cover money laundering as a topic. There have been things which I've focused on in the past, which I'm going to skip over today because there are lots of new things that we need to be taking on board. But I will take you through the whole shebang from start to finish in the next hour. What I always do when I talk about money laundering is I always have this introductory slide on financial crimes generally. Money laundering is at the top of the list because my contention is that if we are doing our money laundering job properly, that to some extent answers the majority of the rest of the list. So doing the deal is a criminal offence if it involves criminal property as part of the links in the chain. Receiving money, having money, transferring money, these are the things that we do on a daily basis. But they all circulate around the notion of criminal property. And that is defined in Section 340 as the direct or indirect benefit from criminal conduct, which we know or suspect to be such. Now, criminal conduct is anything which can constitute a criminal offence in the UK, and there are a number of examples in the italics at the bottom of the screen. The one bit of good news that comes from this is that for us to be guilty of this offence, we must know or suspect that property has been derived from criminality. If there is anything at all about any of those factors that appears in any way odd or unusual, you must ask for clarification now. You don't do what I might have done as an article clerk and think, oh, this looks really odd to me. I'm sure the client knows what he's doing, so we'll just get on with it. Not anymore. You must ask for clarification. Chances are it is all perfectly legal. You just need to know why and how. It's not tipping off, it's just legal advice. You're just satisfying yourself that there is no illegality involved. But to that extent, I would say keep a record of anything that you find.